go ahead and talk about the San Francisco Association of Realtors forms. Before I go into it, I want to explain to you why I'm teaching these forms. The reason is, if I don't teach you these forms, you don't know they exist, number one. Number two, you don't know how to fill out this form. Number three, you don't know the differences between the CAR form and the San Francisco Association of Realtors forms. We also still have the PRDS. The San Francisco Association of Realtors forms are used in the San Francisco area. Anything from beyond Daly City and north and within the whole San Francisco County and San Francisco City. And then from Daly City all the way down to about Palo Alto, most of the time they use the PRDS form. Everywhere else we use the CAR form. There are times when they will accept CAR forms in these two areas where they use PRDS in the San Mateo County area, and also in San Francisco where they use the San Francisco AOR purchase agreement. There are people that ask me, well, can you tell me the difference between the practices there and here? I say, well, the best way to learn about it is to attend the Webex, because no matter what I say to you, you know, I may not be able to cover everything. But when I do the training, I try to be as thorough as I can. Now, some of you that are located in Southern California, you may have transactions in Northern California. So you need to kind of know, well, how we do things differently in San Francisco or in the Bay Area. For one, the escrow fees and the title fees allocation is so different than Southern California. In Southern California is very easy. Everybody pays 50-50. Buyer and seller pays 50-50 for escrow. And then for title, it's always going to be the seller that pays for title insurance in Southern California. It's pretty much uniform. In the Bay Area, it's quite different. How are they different? The best way would be to look at this Google Drive. And please do not ask me again, since I'm already telling you where to find it. It's in your agent's folder. All agents should have access. All Centermac agents should have access to the agent's folder. If you don't have access to the agent's folder, it's because you have not made the request yet. But also it could be because you're still a student, you're not an agent yet. So within the drive, this is the folder you want to access. It's called Who Pays What Closing Costs. And this is actually put together by First American Title Company. Inside this folder, there is a PDF. And it has pretty much all of the counties within California. No matter which county your transaction is in, you always have an answer here. The ones that are more complicated are Contra Costa. Contra Costa, the buyer is paying for escrow fees and title fees. And then the seller will pay for county transfer tax. You may have noticed one thing, that in each and every county, the seller pays for all the transfer tax. For the county, city is something else. You see, all the county, the seller pays for county transfer tax. That is the documentary transfer tax. That is $1.10 rate, okay? We all know that. $1.10 per $1,000. But if you are in different counties, if you are not in Southern California, then you have to consult the chart. Say, for example, San Francisco, the one we're going to be doing today. Buyer pays for title fees, and buyer pay for escrow fees. So these are paid by buyer. Seller pays CD transfer tax, if any. So if there's any CD transfer tax, the seller will pay for it. So when you complete your purchase agreement, this is what you need to consult, or else you don't know who's paying for what. And then on the CD transfer tax, in San Francisco, this is the chart for the CD transfer tax. So if your buyer asks you, at least you'll be able to tell them how much the CD transfer tax is. You're looking at this. If it's $100 to $250,000, is $2.50 per 1,000. Actually, it's actually not per 1,000, per 500. So basically $2.50 per 500. That is very high CD transfer tax. So in San Francisco, figure out what the CD transfer tax, you use this chart. Okay. Now in Berkeley, if you go to Berkeley, Berkeley is Alameda. I don't see Alameda because, oh, the first one. You see Berkeley here, the CD transfer tax is $15 per $1,000 purchase price. That is very high. Oakland is even the same as Berkeley, right? That's probably the highest throughout California. I have not seen anything higher than that. Even Palo Alto is only $3.30 per 1,000. Okay. Yep, Berkeley and Oakland has the highest CD transfer tax, $15 each for $1,000 in purchase price. Okay, now having discovered that, San Francisco Association of Realtors says San Francisco Purchase Agreement. San Francisco Association of Realtors Standard Form. It is intended to be a legally binding contract for the purchase of real property in San Francisco. It has the first part, it looks like a card form. However, in San Francisco, there are many properties that consist of TICs as property owners. So it's not uncommon in San Francisco for people to just sell the TIC and not sell the entire 100% title. Even the TIC is fee simple. So if you're only buying 50% interest, then you have to check here. Then you say this is a purchase of a 50% undivided interest in the entire tenants in common property above pursuant to the attached TIC purchase addendum. You do not see a TIC purchase addendum form in CAR. So in San Francisco, they actually created their own. So if you are not a member of the San Francisco Association of Realtors, you may have difficulty getting the form. So if you don't have access, there are only two ways to resolve the problem. One is you ask the listing agent to give you the form. Like in this case, we asked the listing agent to give us the form. Or you can join as a member. Ultimately, we will have an office in Millbrae. Once we have an office in Millbrae, we will have more and more agents in the area, and they will be using this form more frequently. Okay? So when we have an office in Millbrae, we will be doing more and more transactions in that part of the Bay Area. if you have a TIC situation where the buyer is only buying a partial title, you fill out this part and then you state what the purchase price is for the TIC interest. All you got to do is to type in the number. I assume the letter will show up automatically. But if you are not that situation, you skip this part altogether. Now, in our case, this is what we need to fill out. Your initial deposit is usually 3% of the purchase price. And let me see if I can pull out that. So this is what I filled out yesterday, day before. Initial deposit is 3% of the purchase price. Purchase price is $968,000. And the new first loan is this one here, which is the $677,600. And this number here is called the cash balance. That is the balance of the down payment. Okay? Cash balance is just the balance of the down payment. So A plus F is equal to the down payment. A is the deposit. F is the remaining amount for the down payment. A plus F is equal to the down payment. And then A, C, and F will total up to G, which is $968,000. Just like as is in the car form, the escrow can be stated to close on a particular date or number of days after acceptance, exactly like car form. However, different from car form, it says if COE falls on a weekend or legal holiday, it shall be extended to the next business day. Car form also have a similar definition, but it's not on the same paragraph as it's actually in the definition where they define what a calendar day is or what the close of escrow is, or they define days, business days, or calendar days. But here they spell out very clearly, if the close of escrow date, if 30 days after acceptance, the 30th day falls on a weekend or holiday, then the close of escrow date shall be extended to the next business day. So if Monday is a holiday, and if your close of escrow falls on a Saturday, then the close of escrow shall be extended to Tuesday. This contract, including any addenda and counteroffers, shall constitute escrow instructions of buyer and seller. This is the same thing as car form. The party shall execute additional instructions consistent with this contract and deliver them to whichever escrow company you pick. Financial provision. This one is important because this is different from car form. Buyer affirms that only the loans specified in paragraph 1 are needed to complete this purchase and shall act diligently and in good faith to obtain them. If buyer does not remove this financing contingency within 21 days after acceptance, either party may terminate the contract. Brokers, agents urge buyer to personally confirm loans will fund before removing this financing contingency. This language is not in the standard car form. Buyer further represents that the funds required for the deposits, cash balance, closing funds are available at buyer's disposal, and that obtaining these funds is not a contingency of this contract. This is just clarification that basically what the seller is saying that, you know, as a buyer, you are supposed to make sure all this money that you told me that you're going to obtain to get the loan, you are to make sure that they are in fact available. Any credits to buyer from any source shall be disclosed to buyer's lenders. Again, this one is basically saying that the buyer needs to proceed with the loan diligently. So if there's something needs to be told to the lender, you're supposed to tell the lender. If the total credits exceed the lender's limits, then they shall be reduced accordingly with no adjustment in purchase price. I'm sorry. Let's see here. Any credits to buyers shall be disclosed. Okay. If the total credits exceed the buyer's lender's limit, then they shall be reduced accordingly with no adjustment in purchase price to make up the difference. What that means is that here you have a language that says if somehow the total credit exceed the lender's limit, then they shall be reduced accordingly with no adjustment in the purchase. So what that means is that we don't care, how you use your money. Whatever you do must not change the purchase price. That's what they're saying. Seller agrees to provide prompt access to the property for appraisal purposes, but has no obligation to cooperate with buyer's efforts to obtain any financing other than as specified herein. So basically what they're saying is, as a seller, I will make the property available to you to do your appraisal. However, I do not take responsibility in any manner if you do not get your financing. And I don't have any obligation to cooperate with you other than to make the property available for appraisal. Okay? Appraisal. Now this is just the appraisal contingency. It says here the contract is subject to written appraisal and no less than the purchase price or whatever that amount. This one is a little bit different from car form, but the idea is the same. The appraisal contingency allows the buyer to cancel the contract. If it doesn't appraise at certain number, that number could be the purchase price or some number that the buyer wants to show on the contract. Because the purchase price could be $1 million and the buyer has $50,000 cushion. The buyer can say, instead of using the purchase price for the appraisal contingency, the buyer may say to himself, because I have $50,000 in cushion, I will use this number. I will use 950 or some number lower than the purchase price because I have that cushion. So the way this is written is actually better in the sense that it gives the agent more flexibility when they have a buyer who has an appraisal contingency, but they also wanted to let the seller know, don't you worry about the appraisal as long as it does not appraise below 950 because my buyer has $50,000 in cushion. So you can put a different number here instead of relying on the purchase price. Okay. If buyer does not remove this contingency within how many days after acceptance, either party may terminate this contract. So we decided to have no contingency. That's why we put 0 days here. 0 days means there is no appraisal contingency. Okay? That means that this buyer is confident that the buyer has enough cushion, have extra cash in case it doesn't appraise. Now, in the Bay Area, try having an appraisal contingency. You have to try harder to get your offer accepted because many of the buyers that are successful, they don't have appraisal contingency. So if you have appraisal contingency, you don't compete very well. Okay. So if you can afford not to have appraisal contingency, it's better not to have appraisal contingency. Agency relationship confirmation, this will be just like the car form, so I won't go into it. Dual agency, kind of like a car form. Physical possession, there is a little difference. It says here, physical possession of property shall be delivered to buyer upon recordation of the deed. On car form, it says upon close of escrow. You know, what's the difference? Upon recordation of the deed, is it the same as close of escrow? Slightly different, but one is more precise. Recordation of the deed is actually more precise, but as a practical matter, they are the same. Escrow usually closes when the deed is recorded. Okay? Now, if the seller wants to rent back, you need an addendum. You have to check here. An addendum setting forth terms upon which seller may continue to use the property after COE is attached to and made a part of this contract. Now, this particular addendum, it is similar to the residential lease after sale addendum form, and it's also similar to the seller in possession addendum. Okay, so there is a form, there's an addendum for rent back situation or for when the seller wants to delay giving possession to the buyer. Occupancy. This one basically say whether the buyer is going to occupy the property as the buyer's residence. Same as car form. Title review. Within 3 days after acceptance, buyer advised expense shall order a preliminary title or report from the escrow holder. And in this case, they make the buyer order. In the car form, it's not the buyer who orders. In the car form, it's the seller who provides or who orders. So there is another difference here. And then it says a prelim is only an offer to issue a policy of title insurance and may not contain every item affecting title. This is an explanation to the buyer as to what a prelim is. Buyer shall take title to the property subject to all encumbrances, easements, rights, covenants, conditions, restrictions, and other matters, whether of record or not, as of the date of acceptance, except monetary liens. Number 1. Number 2, any matters which the seller has agreed in writing to remove prior to COE. And that's it. These 2 things. This is something that you don't see on the car form. So I think the San Francisco form is actually better than car form. It explains what a prelim is, and it educates the buyer that having monetary lien against the title does not mean that the title is bad. All it means is that the monetary liens would have to be paid off before you can close escrow. Okay, and then the prelim also may contain things that the seller has agreed to remove. Okay. Now, typically, when we do transactions using car form, the buyer will receive the prelim, and then the prelim is whatever it shows. Certain things, the title company will make sure that the seller resolve it before the title company will allow the property to close escrow, such as deeds of trust, such as governmental liens. Those the title company will take care of it for the buyer. But certain things the title company don't care, which is things like easement. If there's an easement on the property, as far as the title company is concerned, it's not a defect. But the buyer may have a different perspective on it. If there's an easement to the buyer, it's something that they don't want to see. But if they buy the property, they have to live with that easement. Okay. Now, within 3 days after acceptance, seller shall disclose to buyer all matters known to seller affecting title, whether those matters are of record or not. This is another sentence that don't appear on the car form. So this one is actually better for the buyer because it makes the seller obligate to disclose any matters that the seller are aware of that don't appear on the record that also affects title. I'll give you a good example. Say, for example, there is lawsuit and no dispendence has been recorded yet at the time of the sale. And then, just before close of escrow, there's a dispendence recorded. It's possible that the seller may have received the dispendence, but it wasn't recorded yet. The seller might have received a copy. So the seller knew there's a possibility the dispendence will be recorded. But before it was recorded, the title is going to look clean. However, just before close of escrow is recorded, if nobody follows up to get an updated prelim, then they will not see the dispendence. And then the escrow closes. Well, actually, escrow won't close because they will do a last-minute check on this and they'll see a dispendence. However, what if the dispendence was not recorded until escrow closes? Now, if the dispendence is not recorded until escrow closes, the dispendence has no effect on the buyer's title. Buyer's review and approval of the prelim and all the matters affecting title is a contingency of this contract. Here's another thing that you don't see in the car form. Car form, the buyer's review and approval of the prelim is not a contingency because it's not a separate contingency. However, it might be a contingency that is included in the general contingency for inspection. Here you have a separate contingency, which is buyer's review and approval of all matters affecting title. So you need to be aware of this. If the buyer does not remove this contingency within 5 days after acceptance of the prelim, either party may terminate this contract. So you need to be aware, if you're a buyer's agent, that your buyer has an obligation to remove this contingency. But before your buyer removes this contingency, you need to make sure your buyer has received the preliminary title report, or else he will be removing this contingency without having seen the preliminary title report. And then it also says, as COE, buyer shall receive a grant deed conveying title, including associated rights owned by the seller. If the property is a co-op apartment, buyer shall receive a pledge or assignment of the stock and assignment of the leasehold interest. You know, in some places, the property is a co-op. If it's a co-op, is the buyer buying a title or the buyer is buying a stock? If it's a co-op, most likely the buyer is buying stock. Title shall vest as specified by buyer. All right, we'll skip to items included in the sale. Now here you got refrigerator, range, stoves, washer, dryer, wine cooler, microwave, freezer, just like the car form. So this is not much difference. Lease or linen items. That's also the same as the car form. Items excluded from the sale, same as the car form. Prorations and expenses, just like the car form. Waiver of property inspections. You see, it's different from the car form. Car form, we have a separate form for buyer's waiver of property inspection. In San Francisco, the buyer's waiver is not a separate form. It's actually part of the purchase agreement. So to me, in a sense, it's more efficient. Why create another addendum when you don't need to create one? So in a sense, this is actually more efficient. You can actually have the buyer initial the waiver if it applies. If it doesn't apply, then the buyer doesn't initial anything. So, so in a way, it's more efficient. Condominium co-op apartment disclosure. And again, in SF form, they have quite a bit of disclosure and waiver contained within the form. So condominium co-op apartment disclosure, this one basically says if a property is a condominium or co-op apartment, this contract is contingent upon the buyer's review of the documents described below. Within 10 days after acceptance, sellers at seller's expense shall furnish buyer with copies of the property's legal description, covenants, conditions, and restriction, articles of incorporation, bylaws, rules, and regulations currently in force. The most recent financial statement of the HOA and the current operating budget, 1 year's minutes of HOA meetings, the condominium financial disclosure statement prepared by HOA or its management company, and any other documents required by law. The buyer is entitled to receive all of these disclosure documents. Seller shall also advise buyer of any delinquent or special or uncollected assessments, any anticipated extraordinary maintenance or repair expenses, and any pending or anticipated litigation affecting the property. You know, in car form, this disclosure is usually made through the TDS and the SPQ. There's no rule that say you can't use car form in addition to using the SF AOR forms. Basically, this particular form set forth this particular paragraph set forth all of the seller's obligation concerning condominium and co-op disclosure. If it's a co-op, make sure you check this box on the co-op disclosure. Rental property, buyer purchased the property subject to existing leases and rights of parties in possession. If it is intended that one or more tenant-occupied units be delivered vacant, the parties should consult with a qualified San Francisco landlord-tenant attorney. Well, you know, I think this is kind of important. If your buyer is buying in San Francisco, many of the properties are rent controlled. So this is basically advising the buyer to consult a landlord-tenant attorney before close of escrow. Prior to COE, seller agrees that no new changes to the existing leases or rental agreements shall be entered into without buyer's written consent, which consent shall not be unreasonably withheld. So if you're a seller, you're selling your rent control property, and if you have leases that have not expired, and if it's rent control, if there are changes made to the leases, as a seller, you have the obligation to notify the buyer. Within 3 days after acceptance, seller shall deliver all tenants written rental information questionnaire requesting from each tenant acknowledgement of the terms and conditions of the tenant's rental. The rental information questionnaire is a special form, and that's probably another San Francisco Association of Realtor form. So you have to be a member to get that. So basically, if you wanted to be doing a lot of transaction in San Francisco, you kind of need to have access to this form. So you should contact the association to see how you can get access to these forms. I can see why now in San Francisco they don't like to use the DIP form, because there are so many things that are unique to San Francisco that it is better that you use the San Francisco Association of Realtor form to address all of these issues. I will skip, okay? You can read the rest for yourself, but again, these are provisions that are unique to San Francisco. They are not on your car form, okay? Income and expense statement, again, usually on a car form, car residential, RPA, you don't see income and expense statement being a paragraph on that form. So, however, in the SF-AOR form, that is a paragraph that you can use in case you have a rental property. And also another nice thing about the car form, the SF-AOR form, they even have the language regarding 1031 exchange. So in the car form, they don't have such language, so you have to insert your own language. But in San Francisco Association of Realtor form, that language is in there regarding 1031 exchange, so it's kind of nice. It says here, buyer and or seller intends to include this property in an IRC 1031 exchange, subject to the terms of the attached addendum. Any exchange is not a contingency of this contract unless specified as such in the addendum or elsewhere. So the contract itself has a paragraph on the intent to exchange, to do 1031 exchange, plus it also allows the use of an addendum for 1031 exchange. So in that sense, it's a better form than car form, okay? And then over here, you can state whether the contract is contingent upon the sale of another property owned by buyer. Oh, that's a different contingency. This one here, we have that in car, which is a sale of buyer's property. Seller mandated and contractual disclosures. The mandated disclosure are as required by law, such as 19A TDS, 19B, San Francisco seller disclosure. In case you have never done deals in San Francisco, they have a separate disclosure required in San Francisco, and it's a separate form. It's called the San Francisco seller disclosure, and it applies to all properties. So in every single San Francisco deal, it says here, even if exempt from delivery of a TDS, seller shall complete and deliver to buyer the San Francisco seller disclosure, which shall be deemed complete when the seller has answered all applicable questions and initial and sign each page. But it is a separate form, which you do not have in the car form. And that's another reason why in San Francisco, many agents, local agents, wants to use the San Francisco Association of Realtor forms because it's more complete. Or else it's a lot of work to try to add these paragraphs to car form. Okay, I can see why they need to have their own form. NHT, we know about that. Earthquake hazard disclosure, we know about that. Lead-based paint, we know that. Building permit history applies to all properties with residential units except new construction. Seller shall provide a buyer a current report of residential building record. This is called the 3R report. Now, if you have done deals in San Francisco or Daly City, 3R reports are usually required. So this paragraph takes care of the 3R report. And that's something unique to the San Francisco AOR forms. Brokers or agents do not investigate or verify the accuracy of the information in the 3R form. Buyers advised to investigate to buyer's own satisfaction the status of zoning, permits, or code compliance. Okay, anyway, so this one is letting the buyer know that the buyer is entitled to receive the 3R form. And it's also letting the seller know that the seller has an obligation to provide the 3R form to the buyer. Complies with other state and federal laws. Smoke and carbon monoxide detector, we know about this one. Water heater, we know. UST is something that is not in the CARB form. That's the underground storage tank. Okay. Now this one here has to do with San Francisco Health Code. It requires owners of real property in San Francisco with UST. But you know what? Residential, we don't have the UST issue. Okay. So obviously, this is form that is not limited to just a single family residence because it may be applicable to other types of properties. Energy and water conservation. We already have this type of forms provided for in CARB form. Illegal units or rooms. Now, the CARB form does not address illegal units or rooms, but the San Francisco Association of Realtors form does address that. It says, buyer understands that units, rooms, or additions to the property may not have been legally permitted. They may violate zoning ordinances, may have been built without building permits and a certificate of final completion, and occupancy may not have been issued. Buyer may be required to bring them into compliance or to remove kitchens or other facilities at buyer's expense. A substantial fine may be imposed and buyer may be prevented from renting any illegal units. Buyers are advised to obtain legal advice from a qualified San Francisco real estate attorney with respect to potential claims tenants renting illegal units may have. This is unique to the San Francisco AOR forms. You don't find this in CARB form. So basically, you want to let the buyer know that if you buy properties in San Francisco, sometimes you may be buying units that are illegally constructed, and you're taking the risk if you're doing that. So you should consult a real estate lawyer, okay, regarding the risk associated with renting illegal units. What will happen if you rent illegal units in San Francisco? You could be sued by the tenant in the future for all the rent that was previously paid to you, or you could risk the tenant filing a complaint with rent board. Rent board basically can take some action against you. And then if you are renting illegal unit, and if it's rent control, the tenant doesn't have to pay you any rent going forward. And you may or may not be able to evict the tenant just to fix up the place. So that's the risk you take if you're a buyer. Okay. Residential rent control ordinance. Definitely this is unique to the San Francisco Association of Realtors form. This one basically again is giving warning to the buyer that their property may be subject to rent control. Maintenance law is common, like in CARB form. Gas and hazardous liquid transmission pipeline. This is similar to CARB form. Risk of loss. If the property is materially destroyed prior to transfer of title or delivery of possession to buyer, seller cannot enforce this contract and buyer is entitled to recover deposits already made. This is not found in CARB form. This is unique to San Francisco Association of Realtors form. Basically, telling both the buyer and the seller that if during escrow somehow there is a fire and that fire destroys the property, then the seller cannot force the buyer to buy. However, the buyer can get the deposit back. Condition of property. Seller shall maintain this property in the same general condition as when this contract was signed by both parties until possession is delivered to buyer. Seller shall deliver the property free of debris and broom clean condition and provide buyer a possession with keys to all locks, blah, blah, blah. Here's another good provision that the form has. It is not in car form. Basically, this one tells the seller that the seller has an obligation to maintain the property in the same condition that the buyer saw it when the buyer first saw the place. And to make sure that there is no trash left behind when the buyer closes escrow on the property, something like that. Home warranty plan, and over here, it is no different than the car form. Basically, you can specify who's paying for the home warranty plan. Okay. Tax withholding, same thing as car form. Non-confidentiality of offers, same thing as car form. Delivery of documents can be done by email, personal mail, fax, etc. So same as car form. Multiple listing service, I believe that's the same as car form. Mediation, same as car form. Arbitration, same as car form. Liquidated damages, same as car form. Legal advice on arbitration and liquidated damages. Buyer and seller acknowledge that they have not received or relied upon any representation by brokers agents regarding arbitration and liquidated damages, and that they have been advised by brokers or agents to seek legal advice from a qualified real estate attorney. Now, here's another good one that is not on the car form. And it is on the SF-AOR form to warn the buyer and seller the pros and cons of arbitration and liquidated damages, that they should consult an attorney before they initiate the liquidated damages and arbitration clause. In the car form, there is no such warning, but in the SF-AOR form, there is such a warning. So it is definitely a superior form compared to a car form. And then it says, in the event that only one party initials either clause, that clause shall not be part of the contract as formed. This is also another excellent information, basically telling party that in order for the arbitration clause and the liquidated damages clause to be effective, both parties must initial. If only one party initial and the other party does not initial, none of these arbitration clause and liquidated damages have any legal effect on anyone. Attorney's fees, we know about that. Acceptance. It says here, now you know that in order for acceptance to be effective, the acceptance must be communicated to the other side. What that means is that you have to email a copy of your client signature to the other side for that to be an effective acceptance. Okay? And removal of contingencies. Now, this is like car form where the removal shall be by written removal and not oral. Termination. It says the following provisions apply except for a good faith exercise by either party of a contractual contingency or a statutory right to terminate, which can be done unilaterally by notice by a party. Termination of this contract by seller shall be effective only after delivery of a notice to perform to buyer, which provides at least 2 days to perform contractual terms or remove contingency. Now, the difference between the San Francisco AR form and the car form is they tell you 2 days, no choice. Whereas in the car form, you can actually change the 2 days to certain other number of days. So on the SFAOR, it's fixed at 2 days for the notice to buyer to perform. Okay. Same thing with the seller sending, with the buyer sending to notice to seller to perform is also 2 days. No choice. And then regarding close escrow, it says the obligation to close escrow as provided in paragraph 2 above is a contractual term requiring notice to perform. Now, in the case of car form, if one side does not close escrow on time, usually we serve the demand to close escrow. In the SFAOR form, we don't serve demand to close escrow. We serve the notice to perform. It's called buyer may terminate this contract. Either party may issue a notice to perform no sooner than 2 days prior to the contractual deadline. Obligation to close escrow as provided in paragraph 2 above is a contractual term requiring a notice to perform. Release of funds from escrow will require mutual, consistent, signed instructions from both buyer and seller, or the rendering of a judicial decision. Well, this is nothing, it's not different from the car form. Basically, if there's a dispute over deposit, the escrow will need two-party signatures before they release the fund. Broker compensation, there's not much to talk about. Representative capacity, it is another addendum. Okay. Now, I don't know. I haven't seen the San Francisco representative capacity signature disclosure form yet. It might be the same as the car form. I don't know. But such a form exists. Wire fraud, you know, they warn about wire fraud, but usually when we use the car form, the wire fraud advisory is in the offer package. In San Francisco, they have an addendum called the AS or as-is addendum. I don't believe we have as-is addendum in the car form. So this is another San Francisco Association of Realtors form. Now, we all know what as-is means. Does as-is mean you don't have to disclose material facts and commit fraud on the buyer? The answer is no. As-is simply means that you still have to make your disclosure, except that the buyer cannot force you to make repairs. That's what as-is means. As-is addendum, and it is just that there is disclosure about square footage, lot lines, neighborhood nuisance issues, including noise. Okay. It says here, nothing in this article relieves a buyer, seller, or prospective of this duty to exercise reasonable care, okay, to protect himself or herself, including those facts which are known to or within the diligent attention and observation of the buyer or prospective buyer. Basically, what they're saying is that as a buyer, you still have to exercise your own reasonable care. What does it mean if you're a buyer? You know, as a buyer, the law actually requires that you do your walkthrough and look at the property. You cannot just say, well, I don't need to see the property, but I'm going to buy the property anyway. No, you still have to look at the property and do a walkthrough of the property. Now, here it's they say some things that are kind of important, educational to buyer. It says here, seller is not relieved from compliance with any statutory obligation with respect to the sale of the property, including TDS. So even if you're selling as is, the seller still has to complete the TDS. C says seller will not investigate public records for the property. So basically, this protects the seller. And the buyer has not relied on and will not rely on any oral representations or warranties from the seller or brokers or agents with respect to the condition of the property. Buyers relying on buyers' independent investigation of the property. Now, that's kind of like the law in California. If you're a buyer, you're basically on your own because the law says you have no right to rely on agent or, well, it's not that you have no right, but this particular statement basically say that you have given up your rights to rely on any representations made by the agents or the brokers. So the agent may have said certain things about the property, all right? And if it wasn't done intentionally, you can't sue the agent because here you are agreeing to do your own investigation. So it kind of protects the seller and it protects the agents. Now, California law requires the seller to disclose all material facts. However, what may be perceived as material may vary from one person to another. Therefore, in executing this addendum, buyer acknowledges that the property and its components, appliances, fixtures, systems, and materials have varying remaining useful lives. It's kind of like the roof situation. If your roof only have 1 year to go, you have to tell the buyer that my roof only have 1 remaining year of life? No. You don't have to say that. Okay? Because you know why? You don't know whether it's going to be 1 year exactly. That's the problem, right? Okay. And then it says, not all component improvements or fixtures on property may comply with current code. Yeah, the buyer has to know that. Not everything is done in compliance with the code. So, you know, if you want to find out if something is in compliance with the code or not, you hire your own inspector and let the inspector tell you. Square footage approximation only and should not be relied upon. So this also protects the agents as well as the seller. Lot lines cannot be reliably determined by existing fences. We know that, right? Because that is usually not accurate. So this is actually more protective of the seller and more protective of the agents. So the more you should use the SFAOR form if you're in San Francisco. That's right, as a listing agent. Now I see why they insist on us using the SFAOR form. It's more protective of the seller and listing agent. And then it's also say about neighborhood nuisance issue can be subjective depending on varying personal sensitivity. So this is also a good language to have because you know why? What is noise to you may not be noise to another person, right? So this is also a good disclaimer here. Future or ongoing construction at surrounding properties can obstruct view corridors. So yeah, this addendum is actually pretty good. You know, it's actually a good as-is addendum to use if you are a seller. Okay? Another reason why we were asked to use the SFAOR form. Okay? Contingency removal form, they have their own, but this is kind of like similar to what we have for car form. Okay? So that's it for today.